Hello, good evening, everyone, and welcome to the Bar Council's Civil Legal Aid Billing Seminar. This is the first time in 3 years we've held the billing seminars, and we're delighted to be back. I'm happy to say we're joined by three experts in civil legal aid billing who will be talking us through a number of topics today. Before I get started with introductions, just a few points for housekeeping. This session is being recorded and the recording will be made available afterwards on the Bar Council's website and in a link shared over email. There will be time for questions at the end of the presentations. So if I could ask that all questions are posted in the Q&A box rather than the chat in the webinar, you can pop these questions in at any time and we'll get to them after the presentations. And also live transcription is available and can be enabled by clicking the live transcription button at the bottom of the Zoom window. So as I mentioned earlier, I'm delighted that we have three expert speakers who've kindly agreed to be part of this evening's seminar. Our first speaker of the evening will be Stephen Barker, who's Operations Manager in Civil Billing and the Policy and Change Lead at the Legal Aid Agency. So Stephen's been with the LAA for over 20 years. His current role is as the Operational Lead on projects and initiatives that impact civil billing, and he works with both the policy and transformation team to ensure the LAA's processes are fit for purpose. He's a subject matter expert in civil billing, in particularly high cost cases, and he has an extensive understanding of CCMS and previous paper-based billing systems. So today, Stephen will be covering common mistakes while using the LAA platform, as well as the LAA perspective on claiming enhancements. Our next speaker of the evening will be Sumaya Gilmore. Sumaya is the head of revenue at Garden Court Chambers and has been clerking for over 20 years. Before joining Garden Court Chambers, she worked at Tukes Chambers, dealing with all aspects of civil practice, including billing, and she was a senior clerk at another chambers with primary responsibility for family and civil work, including billing and credit control. And before becoming a clerk, she worked at court service for 7 years, dealing with listings in all practice areas. So Smile will be presenting today on exceptional case funding, as well as her perspective on claiming enhancements. And our last speaker, and certainly not least, would be Charlotte Flanders. So Charlotte is a cost lawyer and founder of Veritas Professional Legal Services. Charlotte's been a cost lawyer for over 10 years, and she was originally called to the bar in 2007, but entered the world of costs in 2008. So Charlotte has a particular interest in cost matters, which are funded by way of legal aid, and regularly assists with inter partes bills. And Charlotte deals with most types of legal aid, particularly complex high cost matters, and she was appointed as an independent costs assessor in 2021. Charlotte will be speaking to us today about high cost cases, how to apply for authoritative to counsel interim cases, hints and tips, and as well as enhancements. So I will leave it to our first speaker of the evening, who will be Stephen.
Thank you and good evening, everybody. So my name is Stephen Barker. My official title, although it was previously mentioned there, is quite long and wordy, but actually in reality, I am effectively just making sure that our operational processes are fit for purpose, and whether that's within systems that we currently use or within policies as government policies change or the priorities change, making sure that we have the necessary operational resources to make sure that we can pay the bills. In essence, quite often our mantra is we look to pay the bills. We try to get the bills paid as quickly as possible, and that is my job to make sure that our caseworkers have the tools to pay the bills. I was going to not mention the cyber incident, but I feel it's prudent, since I've been invited back to give a presentation, to mention the cyber incident, and obviously I'd like to apologize for the impact that this has had on the bar and counsel generally, as well as providers and clients. It's not the way that we want to run legal aid, and currently with our systems down, we are, running a contingency process, and that isn't ideal for everybody. What I will do is I'll share my email address at the end, and if anybody is having any problems or any issues with the contingency process, then they can contact me direct. But I just wanted to put it on record there, and that we are very sorry that the cyber incident has impacted barristers and clerks being able to bill out their work, which they would like to do. And if it's any consolation, our caseworkers are equally frustrated in that they can't do the job that they want to do, which is pay the bills. Our caseworkers pride themselves on paying bills, and not being able to do that at the moment while our systems are unavailable is frustrating all around. So I just wanted to put that on the record to begin with. But it's interesting that it was mentioned that the previous session was 5 years ago. I assumed there'd been a few in between, because I did actually deliver the presentation in 2022. So it's interesting that, I was in a sort of post-COVID world. I was, delivering a presentation on this very subject to the bar, and I'm really pleased to be invited back to go through and deliver a presentation again. What I'll try and do today is run through the subjects that I'm going to cover. So quite simply, high level, we're going to be looking at claiming enhancement on certificated billing. And I know Charlotte is going to cover off similar topics later, so it'll be interesting to see from a different viewpoint how a cost lawyer looks at that compared to what the LA would. I'll run through some general claiming tips on CCMS billing, getting it right first time, which, as I mentioned, is something that we're really keen to promote. And the last one, which may become more pertinent with the Hillsborough law and Hillsborough bill, going before Parliament, in certificated inquest billing, and how that links in to the current process. I won't touch on any sort of projections of what it might look like in the future, but just running through what it currently looks like, and that'll obviously bring it to the forefront of everyone's mind, given that it is quite a high priority government policy change at the moment. So the first area I'd like to talk about is enhancement, and this is always a tricky one. I think not just providers and counsel, but caseworkers also, they struggle with the subjective nature of enhancement. There are obviously rules and regulations, and I've covered off a few there. So it's obviously for counsel, it's for hourly rates cases issued after the 2nd of December 2013. I've listed the cost assessment guidance, and there is a chapter in the LA electronic handbook around enhancement. But one of the more difficult aspects of enhancement is that it is subjective, and the way to sort of avoid falling into pitfalls of getting your enhancement reduced, or finding that your enhancement is always getting refused, whether that be on standard billing or high cost billing. I'm going to try and cover off some tips and some sort of areas I think that might help, as well as a little example at the end that might give people a few ideas around how they might articulate their sort of submissions for enhancement. Just covering off some high level information here, so that the maximum of 50% is allowable in the county court. So that's 50% enhancement on top of the hourly rate, and that's a maximum 50% in where proceedings are in the county court. Anything in the High Court or equivalent, or the proposed High Court, is 100%, and that's the maximum that you can claim. So that's for things like judicial review that are perhaps proposed to be in the High Court, Court of Protection, those sorts of proceedings, as well as proceedings in front of a High Court judge or equivalent. Now, caseworkers will consider both the enhancement claimed by the solicitor and the instructed counsel when making their decision. And that's one of the reasons why in non-family billing that we have to consider both the solicitor and the counsel bill at the same time. We need to get that full understanding of the case and that full picture in order to make a judgment around enhancement. If, for example, there are really exceptional factors involved in the case, and both the solicitor and counsel are claiming that they have, gone over and beyond, and they're demonstrating effectively the same the same reasons for enhancement. We need to understand why that is, and it may be that we look into the details of the case and make a decision that perhaps the counsel is due the enhancement, or the solicitor, or both, or in very rare cases neither. But I'll get onto that in a bit more detail on the next few slides. But that's just giving you an understanding about why we need to consider both the solicitor and the counsel bill at the same time, particularly on CCMS, is so we can make that judgment call. If we looked at a bill in isolation, we wouldn't get that wider picture around, counsel is indicating that they have done the work that perhaps the fee earner would have done. But then when we look at the solicitor bill, the solicitor is actually claiming for the work that the fee earner has done. And it's just understanding how they all fit together into the picture and then making a judgment call on what level of enhancement is claimable. There are no guaranteed enhancements in non-family civil cases. So unlike in family matters where you have the guaranteed 15% panel membership, in non-family cases, that isn't applicable. And therefore, any enhancement that's claimed must be fully justified. And that is, and justified within the details of the case, whether that is justified on the bill narrative, on a CFA 1 form, or on the notes in the case plan, or a fee note, whatever method that counsel or the clerks use to justify that enhancement, we will accept any of those forms as evidence for justification for enhancement. But you must justify your enhancement if it is claimed. There are no guaranteed minimums. So what factors are involved in claiming enhancement? You've probably seen all these before, but I'll just run through them quickly with a little sidebar on each one. So expedition, acting for a client at really short notice, for example. Has it been, counsel's been put on the spot, or counsel's agreed to take on work that perhaps, another counsel has been unable to act, so they've taken on the work at short notice. There's another reason why they have particularly taken on the case. They've got that particular expertise in law, and it's only become available or sort of it's only become aware that they are needed quite late on in the case, so they've had to work quickly and expeditiously. The next one is exceptional competence, skill, and expertise. So counsel has used their knowledge in a novel point of law to progress the case. So we do know there are some barristers with particular expertise in areas of law that are highly sought after. Don't just assume that we're going to know that they are an expert in immigration, for example, or that they are an expert in mental health. Spell it out in the sort of explanation and the reason for the enhancement. The next reason would be exceptional circumstances or complexity. So a particularly difficult case or a high profile matter. We do see a lot of those, obviously, in immigration, SIAC cases, as well as some of the mental health matters and inquests, obviously, that we'll get onto. The level of responsibility shown by counsel. Counsel takes on an unusual workload compared to the fee earner instructed. That may be they have a better rapport with the client. The fee earner was unable to do part of the work, so the barrister took on that extra level of expertise and that extra level of responsibility. And then we get into a couple that are a little bit overlapped with the ones I've already covered. So care, speed, economy, of which the case was prepared. So this is where the party's particularly vulnerable, or the counsel goes above and beyond to show the economy when billing, and that might mean that they've had an ability to save time as part of the case by preparing a bundle, and in a particular way that means that it's not necessary to then repeat the process. So they're saving time on the fund in effect, and that can be a reason why enhancement can be claimed. And the last reason is the novelty, weight, and complexity of the case. So this is very similar to a few of the other reasons before. But is there anything in particular that made this case stand out as difficult that would mean that the barrister would attract a higher rate of enhancement? So each claim for enhancement must not be generic by nature. That's what I was trying to get across earlier on. You must tie the reasons for the uplift to the specific details of the case. This will make it much easier for the caseworker to follow and the caseworker to then allow the level of enhancement that's been claimed. The list of reasons that I've gone through above are not a checklist. So don't think, oh, well, 5% for that, 5% for that, 5% for that, 5% for that. That's not the way it works. Those are reasons for enhancement, but you could have one of those and still claim the maximum, or you could have a combination of them and be, down on the lower side of enhancement. It's all about the specific details of the case and how it links to the work that councils did. And one final point, there is no basis for arguing the proceedings within specific categories of law will inherently attract enhancement. I think this was a previous throwback to when the clinical negligence used to get an uplift of 60% on the rates, and I think it was 75% at one point, just by the nature of clinical negligence being that complex area of law. That doesn't exist anymore. That there are no minimums, is what I was saying earlier on. You can't just assume that something is guaranteed because of the area of law. You need to explain and detail exactly why it meets the criteria for being exceptional and what level of enhancement it would attract. So what I've tried to do is just a little example. Please don't copy and paste this. It is very much just me just making this up on the cuff. So this is just an example of a mental health case. So Barrister A was instructed at a very vulnerable client in court of protection proceedings. The barrister was instructed at short notice and giving 2 days plus a weekend to familiarize themselves with the case, with a hearing on Monday. So you see how I've straight away gave that little bit extra detail. You could have just said that the barrister was instructed at short notice, but just giving that extra level of detail about why was it short notice? What do you mean by short notice? 2 days and a weekend, to get themselves up to speed with the case. That is expeditious. The next, but Barrister A met with a client at a hospital and liaised direct with both the client and their guardian in the proceedings. This was extremely challenging given the client's mental capacity. And again, this is just explaining specifically why this was a complicated case, what made it complicated, and having to deal with a client who lacked capacity meant that the taking instructions was difficult, both from the client but also their guardian. And if you can put a bit more detail in there as to why that was, again, that is another reason to justify enhancement. Using their empathy and significant experience of similar cases, Barrister A was able to obtain clear instructions and articulate to the guardian the steps ahead. So, this is what we're talking about earlier around particular barristers who have a skill or a particular experience in an area, spell it out, say this particular barrister is an expert, and the reason their expertise in this particular case was used meant that we're able to get to that point where we're understanding what the client wanted and what the guardian wanted. And at the hearing, the barrister led on all the advocacy, took responsibility over the fee earner to not only conclude the case, but also ensure that the client and the guardian were kept up to date at all times at the end of the hearing. So they've took on a little bit extra responsibility there ahead of the fee earner, and that is why we are seeking enhancement. And at the bottom, I've put on 50% is claimed on the above, and I've explained which of the criteria I believe are met. Of course, that 50% might be much higher. I've just used 50% as a middle ground for a high court of protection case, but that just kind of gives you a bit more detail around exactly what we're looking for when it comes to the level of detail and how it ties specifically to the case in question. You can't assume that the caseworker is going to be able to read between the lines, spell it out, and that'll ensure that the caseworker is able to understand the reasons for any enhancement are claimed. All right, so I've rambled on a bit there about enhancement. The next one, I wanted to do a lot more slides here around what the provider side of CCMS looks like, but obviously as I touched on earlier, the system's being down, I was unable to take screenshots. What I am happy to do is when the system is back up, I'm happy to update these slides with a few more screenshots around specifically what it looks like. But what I thought I'd do here is just run you through some of the basic principles of non-family claiming on CCMS. I mean, one thing to say is straight away, there aren't a lot of things that barristers get wrong on standard non-family billing. The reject rate, for example, on for council bills in non-family cases is below 5%, which is really, really impressive given that the national overall reject rate is around 12%. So it just goes to show that the council and clerks are getting it right when they're billing for non-family cases. Some of that is down to the way CCMS is designed, which I'll touch on now, but a lot of it is down to the way that council clerks bill and the expertise they show when they're billing, understanding what we need and getting it right first time. So the first line here is council cannot submit a final claim for costs until the solicitor final has been lodged. So until the solicitor bill comes in, council can claim POAs, payments on account, but they can't submit interim bills and they can't submit final bills themselves until that solicitor bill has been lodged on CCMS. And that is, again, just harking back to what I mentioned earlier around the need to assess all the bills together. And we can only do that if we receive them all together at the same point. A notification is sent to each assigned council when the solicitor final bill is submitted, and the solicitor bill is held pending the response from each council. There is a specific task that appears on our side of the system, which just updates us that the council have been notified and we're pending and waiting for their submission of the bill. Council would normally reply to this either to say, okay, I'm ready to bill, I have already billed, or I don't intend to bill. One thing I would suggest is that I know sometimes when you get a notification, it might be, you might want to just click reply and say, oh, I'm intending to bill, I'll bill in due course. But if you do that, that might mean that if there is a delay on your side, it might just mean that, that the solicitor bill gets released into the queue early. So I would always advise using that 7 days that you've got to respond to the notification, and then responding and saying when you're ready to submit your bill, not before you're ready. Otherwise, like I said, you do get you do run the risk of the solicitor bill being rejected. And the last part is, you can decide to claim your costs as part of the solicitor final bill, which I'll come on to now. So CCMS in family cases doesn't allow a solicitor to bill on behalf of council, which obviously used to happen in the pre-CCMS world. Council would just be put onto their bill, under the solicitor bill, and the cost would be paid to the individual barrister. In non-family cases, the council can submit their claim for costs within the solicitor bill and avoid having to bill directly for themselves. And I'll just come on to that now. So the option is available, as I mentioned, in non-family proceedings only. We have found that it is only used in a small minority of cases, and I'd be interested to understand the feedback as to why that happens. I think a lot of times council get their allocation on CCMS and then they're just happy to bill for themselves. But we do see, on certain cases, particularly ones I think where inter partes costs are recovered, that the solicitor will report council fees within their own bill. So when that does occur, council fees are paid to the solicitor, and the solicitor then passes the money on to the council. So that perhaps is why it's a bit more applicable in those inter partes cases where the balancing of the costs is a little bit more difficult in terms of who gets paid what and who's already been paid by what amount. The evidence that council would need to supply in order to confirm that they're happy for the solicitor bill would be a fee note, a signed fee note, or signed evidence just confirming that the barrister is happy for council to bill, and their cost allocation should be reduced to 0 to indicate to us that we're not expecting a bill from council. Once that's happened, then we're absolutely fine with that process going on and the solicitor billing on behalf of council rather than council having to submit their own bill. And yep, so as I mentioned, there is an advantage to this process in that you don't have to coordinate your submissions, particularly where there are multiple council involved in high cost cases, or those or similar matters where it is really, really difficult to get 5 or 6 council to bill at the same time within that 7-day window. If it's more appropriate for the council to say to the solicitor, please include my costs on your bill, then they can do that. The current use of the process, as I mentioned, occurs most in inter partes costs, where there is only really a small amount of legal aid claim on the fund. But we do see it in other instances where there is a really good relationship between the solicitor and council, and they are happy for the solicitor to bill on their behalf. But a lot of it will come down to purely what is the relationship between the solicitor and council, and whether that level of agreement is there and in place. And lastly from me, because I appreciate I'm running close to time, so The last subject is, I've only got one slide on this one, and this is on certificated inquest billing. So inquests at the moment are granted uncertificated for the advocacy via exceptional case funding, and it's split between legal help controlled work element, which is everything up to but excluding the advocacy at the inquest itself, and the certificated element, which is the advocacy. Counsel, if counsel has undertaken work under legal help, that would be claimed as part of the solicitor submission, and that would only be able to be billed by the solicitor when the inquest has concluded. Only work in relation to the advocacy can be claimed as part of the certificated work. Preparation, attendances, etc. are all part of the legal help bill and not on the certificate. Counsel under the certificate element is paid an event style graduated fee, so a bit like the old family graduated fee, in that you get the larger fee for the first day and then a smaller amount for subsequent days that you attended the inquest, up to obviously it becoming high cost. These fees will be purely for the advocacy undertaken by counsel in relation to the hearings. When billing on CCMS, there isn't a rules engine built in. It allows counsel to input their own rate, and the rates are obviously very, very simplistic, and with it being a fixed fee, but you only need to upload a fee note as sufficient evidence to prove that obviously this is the fees that you're claiming, and the inquest work is there, as well as obviously then we'll look at that as part of the solicitor claim as well. So just some resources finally. This is the best ways to communicate. Excuse me, I'm losing my voice. The best ways to communicate with the LA. So if it's a specific case on CCMS or just a general query about anything CCMS related, please use the general inquiry method. We have the LA Electronic Handbook. If you search for Google for the LA Electronic Handbook, it should pop up. That is basically the book that we all use, and that's caseworkers and providers. Both of us use exactly the same guidance. It's all transparent and published. I've also put my email address down there. As I mentioned earlier, I'm happy to be contacted on any issues that you'd like escalating or any particular concerns that you've got around the contingency process. Anything non-CCMS related, that is the contact civil email address. And if you are missing any provider statement on accounts or have any queries regarding payments, then that would be the payment information team, whose email address is on there. I've also included a couple of links there to CCMS guides and a couple of things there around making sure that you're signed up for the LA Bulletin, particularly around getting information related to SILAS and other aspects of updates on the cyber incident. And that is me complete. So thank you very much, everyone, for your time. And I'll pass over to the next speaker.
Thanks very much, Stephen. Really helpful and informative presentation. Just as a reminder to everyone, please do feel free to pop in any questions in the Q&A box throughout the presentations, and then we can address them in the Q&A section. And I'll hand over now to Samaya with her presentation.
Okay, hello, good evening, everyone. My name is Samaya Gilmore. I am one of the heads of revenue control at Garden Court Chambers. Thank you all for taking the time to attend this webinar this evening. Just to give a little bit of background, Garden Court Chambers has in the region of 200 members, and we cover most practice areas that are funded by legal aid, so pretty much everything. Today I'll be looking to discuss exceptional case funding in inquest and non-inquest matters, and we'll also touch very briefly on claim and enhancements, but I think Stephen's probably covered off most of what I wanted to discuss already. So if we look, move to my next slide. Oh, that's me. Accepting instructions on inquest cases. So when you're looking to accept instructions, obviously the first thing you need to ensure is that exceptional case funding has been granted. And this will be by way of a public funding certificate. So it'll be the usual funding certificate that starts with the 3000, and it will specify on there that it's to cover inquest proceedings. The exceptional case funding strictly covers the advocacy in inquest proceedings. Running parallel to the exceptional case funding, the solicitors will also have a legal help file. So when you're instructed, you need to ensure, or your clerks need to ensure that they open up 2 files, one for exceptional case funding billing and one for legal help billing. Now, as Stephen has touched on before, there are fixed rates for advocacy on under exceptional case funding, and for junior counsel, the rate is £900 brief fee for day 1 of the inquest, and £450 for subsequent refreshers and for attendance at any pre-inquest review hearings. For leading counsel for Silk, the brief fee for day 1 of the inquest will be £1,800, and subsequent refreshers and attendance at any pre-inquest review hearing is charged at £630. Now, legal help. There's no codified rate for counsel under legal help in inquest proceedings. So counsel are not subject to the rates that are set out in the civil remuneration regulations. So it's important that when taking on instructions that you or your clerks need to agree an hourly rate with the solicitors for work undertaken under legal help. Solicitors may wish to agree the hourly rate they would be subject to under the civil remuneration regulations, or you may want to look to try and agree a higher hourly rate. Obviously, you need to be mindful that it is public funds, so you can't just go in. I wouldn't propose trying to agree council's usual commercial rate, so you need to be mindful of that. Another issue that you need to be mindful of that solicitors might get a little anxious about relates to paragraph 3.60C of the 2024 Standard Civil Contract Specification, the general rules. And that basically stipulates that solicitors must settle counsel's fees in full, irrespective of any reduction on counsel's fees on assessment. So you can imagine that solicitors might feel a bit twitchy about that then they would be liable for any outstanding fees following an LAA assessment on legal help fees. One way of circumventing this is to consider agreeing with those instructing from the outset that you will not look to recover any shortfall on counsel's fees following any LAA assessment or subsequent appeal. So just going back to exceptional case funding, that covers advocacy only. And advocacy is set out in section 4 of the Legal Aid Agency's Inquest Provider Pack as meaning 1, counsel or solicitor acting as advocate; 2, costs of another legal representative attending the hearing if justified; cost of instructing counsel, that is drafting instructions; 4, conference costs before the hearing for the purposes of preparing to provide advocacy; and finally, costs of any pre-inquest review hearing which advocacy is required. Anything outside what I've just mentioned can be claimed under legal help, including counsel's written submissions or written argument. So when you are submitting legal help billing, it is important that your narrative is detailed and clear that it does not relate to advocacy. For example, just saying preparation on your legal help bill is not enough. you need to provide more detail. For example, preparation, reading experts' reports, for example. An example of something that cannot be claimed under legal help would be preparation of cross-examination of witnesses, as that would be considered to be related to advocacy and therefore will be included in the fixed exceptional case funding advocacy fee. So to recap, when accepting inquest instructions, important from the outset to agree a legal help hourly rate and terms in the event of the legal help bill being reduced on assessment. So you need to ensure you get that sorted from the outset with your instructing solicitors. Oh, whoops. So if we have a look, a little discussion on legal aid assessments and inter partes, the legal aid agency may assess down your legal help bill. We commonly see the reasons for this usually being they'll reduce the hourly rate that we've claimed, or they will suggest that the work claimed relates to advocacy. I do recommend you do appeal, but you need to ensure you can justify the rate claimed. For example, that could be based on the barrister's year of call, particular expertise in that area. And you will also need to justify why the work claimed did not relate to advocacy. We have found that we are usually successful on appeal, even after it's been referred to an independent cost assessor, with fees allowed in full or in part, but always usually more than what it was initially assessed down to. As you no doubt will be aware, there'll be some instances where a damages claim may arise out of inquest proceedings, following inquest proceedings, and that can be funded by way of legal aid or conditional fee agreement. If a costs order is granted in favour of the claimant, then all work claimed under legal help, exceptional case funding, and in the damages claim can be rebilled inter partes. It is imperative you provide prompt billing and times for all work done. For example, don't assume you don't need to provide times on the exceptional case funding file because it's fixed advocacy fees. If the matter goes into parties, those times will be needed for rebilling. And the next slide provides some useful links on what I have just discussed. So now I'm going to move on to looking at exceptional case funding in non-inquest matters. Now, solicitors will make an application for civil legal services that fall outside the scope for legal aid. Granting of this funding is determined under Section 10.3a and Section 10.3b of LASPO 2012. Examples of areas of law where exceptional case funding may be granted can be in welfare benefits matters, education matters, and some immigration matters. If exceptional case funding is granted, you need to ensure that you're clear on the terms of funding granted, as it could be under controlled work, which is covered off by Schedule 1 of the Civil Remuneration Regulations, or licensed work, or certificated as we call it, which is covered off by Schedule 2 of the Civil Remuneration Regulations. Or sometimes, although I've very rarely seen this, or an individual case contract. For example, it might be a fixed amount that has been allowed by the legal aid agency for a certain piece of work. Please note that initial work may be undertaken at risk, as it can take the LAA up to 25 days to consider an application for funding, or 10 days if urgent. The legal aid agency can grant backdating of this funding. So based on what I've just discussed, you need to ensure you complete your billing under the correct rates. So what can be claimed? So as I've discussed, it depends on what the scope is, what scope has been given. So you need to ensure or be clear on whether the legal aid has granted that exceptional case funding under controlled or licensed work, and that will be subject to the rates as set out in the civil legal aid remuneration regulations. Now, the next slide here provides some useful links on what I've just discussed. And I've also provided a link to the Public Law Project website, which provides very helpful guidance on exceptional case funding. So I'm going to move on to now enhancements. I don't think I'm going to be able to tell you much more than what Stephen's already told you. I only wanted to touch on it briefly, but as you'll probably be aware, and what has already been mentioned, you can claim up to 50% enhancement on certificated matters in the first tier tribunal and county court, and up to 100% enhancement on certificated matters in the upper tribunal, high court. Reasons need to be provided to justify the percentage claim, and solicitors will need those reasons when submitting the final bill to the legal aid agency. So therefore, I do recommend to counsel preparing your reasons sooner rather than later, to avoid, because of this crossover where we've got to have counsel's bills and solicitors' bills all submitted at the same time, so the legal aid agency, to avoid the solicitor's bill being rejected due to delay on counsel's part for not providing reasons. And this can sometimes impact on solicitors' key performance indicators with the legal aid agency. Stephen's already touched on the thresholds that look to be met when claiming enhancements. As he has mentioned, work done with exceptional competence, skill or expertise, work done with exceptional speed, or the case involved exceptional circumstances or complexity. I would recommend looking to fulfill at least 2 of these thresholds when justifying the enhancement claimed. There is also certain criteria to consider when justifying an enhancement, as set out in the Bar Council's guidance on claiming enhancements, and which Stephen has also touched on, with regards to the degree of responsibility accepted by the barrister, the care, speed and efficiency with which the barrister prepared the case, and the novelty, weight and complexity of the case, which can cover off the volume of documentation or other material in the case, the number of issues arising in the case, and the importance of the case to the clients. I've provided in this slide links below to both the Legal Aid Agency's cost assessment guidance and Bar Council guidance on claiming enhancements. These are both very, very helpful guides and provide more in-depth explanations on claiming enhancements. So I hope I haven't rushed through that really quickly, but that is all from me, and I hope you have found it useful. I'm very happy to answer any questions anyone may have, and I will hand back over to Rowan to introduce our next speaker.
Brilliant. Thank you so much, Sumaya. That was a great presentation. So over to Charlotte with your presentation.
Thank you, Erin. I'll just share my screen. Good evening, everybody, and thank you for the introduction, Erin. As mentioned, I've been working in legal costs for over 15 years. I deal with all kinds, many high cost cases, and don't hold it against me. As was mentioned, I am also appointed as an ICA. But anything mentioned in this talk, they are my own views. So any questions, please do direct them to myself. In terms of what we're going to be covering, first I want to talk briefly about civil high cost cases, and again, probably very briefly about prior authority in relation to two council matters and King's Council. I'll also talk about enhancements, but hopefully I won't bore you, as you've had two very good talks on that already, and followed by my hints and tips. Now, as I only have about 20 minutes to talk, it is very much going to be an overview. These are some very in-depth topics. I could probably talk on civil high cost cases for an hour on its own, although I'm not sure that would be terribly interesting. I have assumed a working knowledge of legal aid, and the final slides do set out some guidance that make good desk aids for anyone who is dealing with this. So I apologise if you feel I could have gone into more detail, but the guides do go into more detail. And of course, there is that Q&A session, so if there are any questions, do please put them in. So, high cost cases, civil high cost cases, what are they? They are defined by the procedure regulations, and I have set them out on that slide. I'm not going to read through each of them. Essentially, it's a case where the likely costs or actual costs are going to exceed 25,000. There are some others where if you have an appeal to the Supreme Court, but in all likelihood you're already at 25,000 if you get there. Interestingly enough, it's only if the costs are likely to exceed 25,000. So technically, a matter could be a high cost case from the outset, because some matters are going to go over 25k. It's unusual, but I have seen it happen that they are registered as soon as the certificate is issued. Just wanted to give a brief overview of the process. So the first step is registration, and that's going to be by the solicitor. So at the point that they recognise that a case is going to exceed 25,000, they should register it. If they don't register it, then there could be a shortfall. And the one time you definitely can't register the case is after the conclusion of the case. So if you've got all the way to the end and you look back at your costs and you go, here's my fee note, solicitor, and they go, "Ooh, that's high, we should have registered it," it's going to be a big problem. So once registered, you'll be looking at the case plan. Ideally, this should be within 28 days. There will be a notification on the CCMS that asks for it within 28 days. They can ask for extensions, but the LAA are fairly picky about the times. The case plan itself, there are example formats online, but it really is for the provider to prepare and decide what format works best for them. I've seen many case plans and no two are the same. You get some case plans that are task-based, you get some case plans that are based on time, so they'll go from one period of time to another. It's really whatever works out best for the case, but they should always do it with your input, with counsel's input and with the clerk's input. So the plan will set out the cost to date, the key information about the case, any issues, case theory, matters relevant to merits and funding. And in terms of the future costs, it should set out the hours for solicitors, for counsel, and for any disbursements. Now, they say that less is more, but trust me, have my kids on this, more is more, particularly when it comes to the information contained within a plan. So it really does help if you justify the costs and set out exactly what assumptions and the expected work is. So don't just say, oh, for that stage to trial, I need 60 hours. That's not going to help anyone. It's not going to help your solicitor. It's not going to help the LAA. But if you say, split that 60 hours into smaller, manageable items and put a reason and say, okay, I need 2 hours with the client, 10 hours considering 500 pages of disclosure, and 5 hours to prepare submissions, then it makes it easier for the LAA to understand exactly what work you'll be doing as counsel, but also in the event something needs amending, which I'll get onto later. Once the plan is into the LAA, it turns to negotiations, which is a phase that is predominantly between the solicitor and the ECC team. As good practice, your instructing solicitor should liaise with chambers if there are any issues with counsel's fees. And then once an agreement is reached, contract documents, which will include counsel acceptance forms, need to be completed and returned. Once they're returned, the limitation can be increased, which allows you to POA. That is quite important. And of course, then there's always the option to update the plan if necessary, which then in turn creates a repetition of the negotiation phase. So I just wanted to run through some notable points in relation to case plans. One interesting fact is that the limitation on the certificate bites at the point of registration. So ideally, it will be fine. Ideally, your instructing solicitor knows what your costs are, they knows what their costs are, and at the point they register it, there's sufficient on that certificate. Because effectively, it caps your pre-contract costs to that limit. So if you have a certificate that's £7,500, for instance, when the case is registered, the pre-contract costs can't exceed that £7,500. So if necessary, your provider should increase the limitation, if they need to the maximum of 25, and then register it. This is why it's important to make sure you're getting your fee notes in. Now, the LAA like agreeing costs in advance rather than approving costs spent. And also, it's just better to make sure those case plans are in with lots of time and that you're not requesting a lot of extensions, because if you keep requesting extensions, or your provider does, then all the work you're doing is essentially at risk because you don't have an agreed plan in place. And the other thing to bear in mind is that late plans can cause significant issues. One issue is that if your provider is late getting their case plan in and they don't have an agreement with the LAA, then the LAA can move what is the effective registration date, thus extending your pre-contract stage, which you might already have maxed out on costs, which could result in significant shortfalls. And there's also an issue in relation to partial cost orders, which could limit your ability to claim legal aid costs where you haven't recovered 100% of your costs from the inter partes, which I will deal with later as well. Extensions can be agreed. So if necessary, communicate with your instructing solicitor. If you need additional time, ask for additional time, and they can ask the LAA for additional time. In terms of the case plan, it should be set out into key stages. Ideally, it should run to the conclusion of the case, and what key stages there are will depend on the circumstances of the case, the type of case, the type of funding. Some cases might only have 1 or 2 future stages, like a JR, whereas you might have a claim against public authority, which tend to be split up into the standard CPR stages. So I can't say there's one stage that will apply to all cases, it just depends. And finally, do bear in mind, it is possible to appeal if they can't agree a case plan. In terms of appeals, the process really depends on the type of plan. So the negotiations are with the ECC team. If you can't agree, it then goes to an appeal. I don't propose going into this aspect in depth, as I simply don't have the time to do this aspect justice. Safe to say that it would be something the solicitor would pursue with assistance from counsel. So bear in mind that if an appeal is required, then be expected to justify your time and the work required. Naturally, this will be much easier to give if detailed information has already been given from the outset. And just a final note is that the LAA can withdraw funding at the case plan stage if the merits are deemed insufficient, which would result in an appeal against that decision. I wanted to talk to you about rates in case plans. So where an inter partes order is unlikely, like a court of protection matter, then you'll be looking at your normal codified rates. Where an inter partes order could be expected, not that necessarily you will get it, everyone hopes that it will be obtained, but that's what it will be, such as a judicial review, then risk rates will apply to those costs over £25,000, which I've set them out there. And essentially, the reason they're fixed is to make it easier for everyone to deal with the costs. But something to bear in mind is ring fencing. So this is where the first £25,000 includes less than £5,000 worth of council's fees, then £5,000 is ring fenced. So even if they go past 25, you've still got this ring fenced amount, which is paid as per the remuneration regulations. And the reason for this is to allow council to decide whether or not they actually want to take on the case before being subjected to risk rates. And if there are 2 council involved, then that ring fence is split equally between them. And finally, there are no enhancements on risk rates, unfortunately. So dealing with amending and updating case plans. When a case plan is agreed and the key stage is agreed, there is a 5% tolerance. So if you need to amend a stage and it hasn't progressed how you expected it to, you need your costs for that unexpected event to be more 5% or more than your specified payment for the key stage. If it's less than 5%, even if it's a really good reason as to why things didn't proceed, you're not actually going to be able to amend the plan. So when looking to amend plans, you need to be specific. What was expected? how did that not happen and what happened instead? The LEA, they do appreciate that you are trying to predict and things don't always go to plan, or maybe council is involved more than they thought they were going to be, and they are amenable to amending them. You just need to be able to set that information out. So it helps if the planners contained enough information in the first place to be able to identify exactly what was planned and where it deviated and how that is more than 5%. And also be prompt. Don't leave it to the last minute. As soon as you're realising things aren't going to plan, start that conversation with the instructing solicitor and getting that amended case plan in. So where a new stage is required, then this involves an update rather than an amendment to the plan. So if you're adding in an appeal, you add another stage. But when you are adding in another stage, it's a good time to do a stock take and go, okay, actually, did the last stage go as we planned? No, well, let's try and amend it and update it at the same time. So in terms of how the case plan impacts upon legal aid billing, one thing to bear in mind is that the costs have to be assessed by a legal aid agency. There's no option for court assessment. Even if there's an inter partes cost order, you can't get the legal aid costs assessed by the court. So the key stages effectively provide a cap as to the amount which can be claimed if you don't get it amended. But on the plus side, you can bill at the end of each key stage. And if the stages are longer than 6 months, you can POA every 6 months. And if just bear in mind that if funding finishes mid-key stage, so if they lose funding mid-key stage, then you work out how much they're allowed based on the proportion. So you say, well, it's 50% through the key stage, and then that key stage is 50%, and that's how that would work on that cap. And in terms of the key stages, the providers are entitled to what I term bonus payments, where they've operated within 50 to 99% of the expected specified payment. So I'll just deal with that very briefly. I have no idea if providers pass this on or not, even though council's fees are included in that calculation. So the payment for a bonus payment is determined by the total value of the claim for a key stage versus the agreed specified payment for that key stage. The specified payment, it means the total amount of the key stage, so the total amount of the solicitor's costs, council's costs, and disbursements. So to put this into perspective, if you have a £10,000 key stage and the provider's total costs, including council and disbursements, works out to be 9,600, then the LEA will pay the specified payment. They'll pay the £10,000. So you've got this £400 bonus. If you say have a £10,000 key stage and your total cost is 7,500, then the LEA will pay the 7,500, but they'll also pay an additional £500 as a bonus for operating within the key stage. And then finally, if you're below 50%, it's just the actual costs. So you want to be good with your budget, but not too good. You know, you wouldn't want to be at 49%. That's a terrible joke, by the way. So always just claim what you actually did. When it comes to the end and you do have an inter partes cost order, there is a final payment choice, which is covered at 5.3 to 5.11 of the specification for individual case contracts. So you can choose whether to take payment under the cost order or under the certificate. And it's a choice for each council and the solicitor. The solicitor's choice shouldn't bind council's choice. They're entitled to whichever is higher. There are many reasons why you might decide to take payment at legal aid rates and leave an inter partes cost order. You're probably where you don't think, or there are going to be difficulties actually enforcing that inter partes cost order. So if you choose inter partes costs, all your legal aid costs will be recouped. And if you choose to go with legal aid costs, then you have to pay in all your inter partes costs. And the provider will have to assist with any enforcement and cost recovery there is. In terms of partial cost orders, and this is where you might say have 70% ordered against your opponent and you've got a missing 30%, unlike a normal certificated matter, you can't automatically change the percentage not recovered from the LEA. You have to apply to the LEA to recover that percentage that hasn't been recovered. And you can make this application at any time, but it's not actually guaranteed. So it is difficult because you have to convince the LEA to make it. So ideally, any cost order should set out exactly which costs aren't agreed. And they don't have to agree to actually do this. there are circumstances where they won't agree to pay the percentage not recovered. For instance, if the court's already said the costs are excessive, if the court has said that an issue was unreasonably pursued, if you've included a lot of arguments that were completely superfluous, then they're not going to pay the cost of that. If your conduct resulted in the failure to recover it. So there are reasons why you wouldn't. One concerning reason why is if you fail to submit a costed case plan outlining in sufficient detail the grounds of claim and defence and argument. So if your case plan is lacking and you didn't give the LEA enough information in the time frame they asked for, and then you don't get full inter partes costs, you might actually be precluded from recovering your legal aid costs. So it's just something to bear in mind. I'm going to briefly cover prior authority in relation to King's Counsel and to Counsel. So by virtue of the standard specification, you can't claim for King's Counsel or instructing more than one counsel at the same time unless you have prior authority. This won't stop a King's Counsel choosing to actually be paid at junior rates. It doesn't stop two counsel having an informal fee sharing arrangement where only one is charging. That's okay as long as only one is charging. And it isn't required if counsel is simply changing. So it is prior authority. It needs to be in place before the work is done. If it's not in place, then you just won't get paid, even if you do it later. So if, for example, you do the work on a Monday, you get prior authority on the Tuesday, you won't be covered for any work you did on the Monday, even if the application was in. And it is worth bearing in mind that there are two things that can invalidate a prior authority. One, inaccurate information in obtaining it. So if you're going to be instructed under prior authority, I would recommend that you actually see the application and what the solicitor is saying, although you will have some input into it anyway. And two, if there is a material change in circumstances between obtaining the prior authority and the costs being incurred, if something does change, just be aware. Know why you've got it and what the information was provided to the LEA to get it. Don't have your cost at risks. In terms of the procedure, so you should obtain the client's consent because it can impact upon the stat charge. Judicial reviews, they might be helpful, but they don't bind the LEA. And whenever an application is made, then they need to be clear. The application needs to be clear about the extent and the nature of the authority required. You need to provide sufficient information and a supporting letter and note from counsel. And there are a multitude of factors to be taken into consideration that I simply don't have the time to go into now, but they are set out in detail at pages 7 to 12 of the guidance on authorities. And I would suggest if you do an application, have reference to that guidance. And lastly, there is no right of appeal against an application for prior authority. In terms of authorities generally, just be really mindful about what you're being covered for, because the terms of what you're being covered for can be very specific. And they are, if they are limited and you do need to do more work, then just make sure that you know that another prior authority application will be required. And turning to enhancements, I'm very conscious I am running out of time, and this has been covered wonderfully by the previous two speakers. Just in terms of enhancements, I just wanted to point out that it is a two-stage process. So you've got the first stage being your threshold. You need to get over that. And then the second is the enhancement. And your rules could contained in the Civil Legal Aid Remuneration Regulations at Regulation 7. I very much repeat everything else that has been said in that every case is based on their own merits. Do provide as much information as possible. Make it easy for the assessor. Be specific about why you're asking it, which part allows your threshold, then which part allows your level of enhancement. Be mindful of what the regulations say. What does care mean? What does weight mean? And just really give that information. So if you're considering something, how many pages were considered? You want to say, oh, I considered 1,000 pages and I prepared a 20-page document and I had X amount of time to the hearing. All these factors will help justify your enhancement on, say, something like expediency or weight. But if you don't tell the assessor, they don't know. And finally, I'll very quickly go through my top 10 hints and tips. Number 1, communicate. Communicate with everyone. Communicate with your instructing solicitor, the legal aid agency, your friendly neighbourhood cost lawyer, you know, everyone you can think of, speak to. Always check your certificates. Always keep an eye on what counsel's costs are and whether they look high. Remember, you will probably see more high cost cases than your instructing solicitor. So bear that in mind. If you think costs are getting high, open that conversation. Provide your fee notes regularly and give timely information when requested. Break down any estimates into smaller time and give that information. And finally, make sure you've got copies of the case plans and any prior authority, your returning work. And generally, just make it easy, give information on the time claimed and fees. And my last slide, it just contains some useful guidance and it's hyperlinked, or when it's shared, hopefully it will find it useful. I'm sorry I had to speed up there, but thank you so much for your time. I hope you found some useful information there.
Thank you so much, Charlotte, for a great and informative presentation. So we can now open the floor up to some questions. So if you do have any questions, you can pop them in the Q&A box. I'll start with some of the questions that are already there. So I believe this first question is referencing claiming enhancements. So it says, can you provide guidance as to what percentage uplift to claim? Essentially, how to decide the amount to claim?
Can I? Oh, sorry, Stephen.
Do you want me to take that one? I mean, the easy answer is, unfortunately, there isn't a checklist for it. It is all case specific, as I think Charlotte has touched on there. We'd love to be able to just say 5% for that, 5% for that, 5% for that, because it would make everyone's life easier. But that would also exclude those exceptional matters that where it doesn't fit into that formula. It's all around experience. And I appreciate, obviously, enhancement's only a relatively new concept for council, but it's about understanding similar cases that you've been involved in, getting that level of understanding and experience around, okay, we claimed 50% for that and it was allowed. We claimed 70% from that, and I can see exactly the same scenarios here. But that's that two-stage threshold sort of test that Charlotte touched on as well, making sure that you don't become formulaic with it. What we want to do is actually avoid it becoming a formula, and it should be more around the specifics of the case and a gut feeling, and then justifying that level of enhancement. I mean, in essence, it's only between 0 and 100% in the High Court. That might sound like quite a large threshold, but the majority of claims that we see in the High Court in particular are between 30 and 70%. Anything above 70%, you're looking at sort of that exceptional area. And it's just, for me, it's all around justifying a figure. And there isn't, unfortunately, a sort of checklist or a sort of breakdown of what we can give you. It's just around using your experience and determining what has been previously allowed. That would then determine, on this particular case, what would be the amount that's allowed. And caseworkers use exactly the same logic. Caseworkers using their experience and their knowledge of previous cases to understand, okay, I've seen a similar case like that where I've allowed 60, 70%, and that's what I'll allow in this case because it's been justified by the detail. But I'll let Charlotte come in if you wanted to come in with a bit more detail there, Charlotte.
Thank you, Stephen. Yes, I completely agree with you. It is case specific, but whilst there isn't a formula and you can't say 5% for this, 5% for that, if you look at the second stage of the threshold, you've essentially got degree of responsibility, care, speed, efficiency, novelty, weight, and complexity. So you've got 7 reasons there that you could potentially hit on, and slightly more even, because when you look at weight, that's volume of documentation, number of issues, and the importance of the case. So you've almost got 9 potential factors that you could be then hitting on. And I would say that where you do have a case where you're hitting on more of these items, then you're going to be looking at a higher percentage to claim, as long as you've set it out and justified it. But equally, if you have just one factor and it is particularly strong, the cost assessment guidance does specifically state that you can get the maximum for one factor. So perhaps you have a particularly vulnerable person whose loss of liberty or their homelessness or something that would make it more important than all these cases are very important, but would make it even more so, then you can essentially say, well, that factor is particularly strong. And the other thing that I didn't touch on at all, I did mean to, is perhaps you've got a case that changes. So you start really urgent. You've just been instructed. You've got to do a lot of out of hours work, and it's a very complex matter. So you're hitting more of the factors. But then the case progresses and it doesn't become as urgent because you've had that hearing and it's moved on, but it's still complex. Well, at that point, what you could do is say, right, I'm going to claim 75, 80, 90% for that first bit of work, or 100% even, because it was so urgent. I didn't sleep, I didn't eat, all I did was work on this. Urgency passes by, okay, now I'm claiming 75. And I think that approach would show a very much considered reasoning to the enhancement that would make it quite difficult to disagree with, in my opinion. Not impossible to disagree with, but you'd be more justified.
I'll just come back in, Charlotte. I completely agree with you. I think it's that understanding, and that, like I say, when I was talking about relating it back to the case, that is a prime example of relating it back to the case, where at different points during the case, different elements of the enhancement criteria were met, and you've claimed different levels. That demonstrates a specific relation back to the case. And if that is mentioned in the narrative, then as Charlotte said, that's the kind of thing our caseworkers would be looking for.
Great, thank you. And our next question is related to inquests. So that says, can you claim all of your preparation time under legal help, or is it assumed to form part of the £900 brief fee? So Stephen or Sumaya, I don't know who'd like to answer.
Goes back to what I said with regards to preparation. You need to be clear when billing what that preparation relates to. You can't assume that you can claim all your preparation time under legal help, because some of that preparation is going to relate to advocacy. So it goes back to what I was saying earlier. You've got to be clear in your narrative, in your billing, what that preparation actually related to. So hopefully it's as clear as that, straightforward as that.
Great, thank you, Sumaya. And we've got another question on inquests. So Stephen said that inquests are paid via exceptional case funding. The Ministry of Justice last week announced the scope of legal aid will be widened to fund representation of families in inquests in more circumstances. Will these cases be billed in the same way, or will it be a different billing scheme?
Oh, there's $1 million question. I've just come off a 5-6 hour call about this very subject. Unfortunately, I can't give you any more detail at this point until the bill passes through Parliament. Obviously, at the moment, it's non-means tested exceptional case funding, with it being equality of arms, and the idea of giving more people access to inquests where a public body or the government is an interested party, then it's likely to be expanded. So unfortunately, at this stage, I can't say any more than that, as much as I would like to. But if you've got any specific questions or concerns, then let me know. But as soon as we're able to communicate on how that will look, we will do. But at this stage, unfortunately, I can't comment. It's not something that I'm allowed to speak about, unfortunately.
Great, thank you, Stephen. And another inquest question. Can you claim for reading disclosure under inquest legal help?
I would say yes, you can, if it doesn't directly relate to advocacy. So yes.
Brilliant, thank you, Sumaya. Okay, another question for the LAA. So it says, is the LAA open to the argument that pre-case plan work might justify a greater enhancement percentage than was offered for the contract work? If so, are there any tips for timing or justification?
Oh, there's a good question. I've had this discussion fairly recently around Court of Protection cases in particular. And I've seen cases go to the independent cost assessor that have sided in both ways. A higher rate of enhancement has been allowed in the pre-contract work compared to the contract work, and vice versa. It's a really, really tricky one to articulate, because in essence, you would have to demonstrate that there were exceptional factors before the matter became high cost that weren't in place when it essentially continued as high cost. And that might be because a lot of the preparation work, a lot of the the legwork was done in the pre-contract phase. Perhaps, as Charlotte mentioned earlier, a lot of the expedition or a lot of the factors that would have been justified for enhancement were in the pre-contract phase that weren't in the contracted part. So perhaps the contracted post 25,000 is purely just attending the hearings and, you know, concluding the case, whereas the pre-contract work has been everything up to that point, including all the preparation, all the liaising with clients, gaining those instructions from difficult clients, looking at that complicated area of law. So in order to demonstrate that, you know, you're looking for that higher level of enhancement and that the level of enhancement isn't uniform throughout the entire case, you're going to have to demonstrate why in the pre-contract costs it was different. And I would try and focus on those things that you've done in the pre-contract work that have then meant that the post-contract work is, you know, not cheaper, but is a lot easier to do and a lot easier to conclude. So one of those tests that we talked about earlier was doing things, you know, that are going to have a benefit in terms of the costs of the case. If council has demonstrated that in the pre-contract, and that has meant that the post-contract work is much less, then I would be demonstrating those in the pre-contract. But you've got to really sort of draw that line about why something is higher in the pre-contract. What is it exactly? And I would be focusing on all of that extra work that was been done in the pre-contract that'll lead on to the successful outcome in the post-contract, particularly around preparation, attendances, and dealing with clients or expedition. They are the usual ones we would see in pre-contract. But again, it's a really tricky one because the case plan team will be looking and saying, well, you know, the level of enhancement is uniform throughout the case because the same factors are involved in all of the case. So to demonstrate that, you're going to have to specifically outline what was different in the pre-contract that has then led on to that higher level of enhancement. I'm not sure if that was a court of protection one, but that is somewhere we have seen it quite recently around court of protection and that differing level of enhancements. And upon assessment and upon referral to the independent cost assessor, we have seen some come back as positive, some come back as allowing, you know, higher, some allowing the lesser amount. So it is a bit of a, it's one of those difficult ones. But I think if you can really set out the reasons why it's different in terms of the work that you've done in the pre-contract, that would be the best way to go. Sorry, I've waffled a bit there. It's a difficult question, that one. A very good one. A very good question, though.
Brilliant. Thank you, Stephen. So my next question is there any news from the LAA as to when the proposed increase to council civil legal aid hourly rates will be implemented?
Nope, unfortunately, I don't have any information on that at the moment. Anything that is updated will be shared with the bar, and that will be communicated with the bar and by the rep bodies as and when it becomes available. But I'm not aware of anything at this moment in time in terms of the increase in remuneration rates.
Okay, great. Thank you. I have another question here, Stephen. I'm not sure if you can also see it in the Q&A box. I just want to ask if it would be better dealt with outside of this meeting.
Just ask it. I'm okay. That's fine. Just fire away.
No problem. So it says not directly related to anything covered today, but could you please confirm the correct codified rate for counsel who is over 10 years call senior, but is neither leading nor being led in the Court of Appeal, so the sole counsel? And the question is referred to section 9.1 of the Civil Finance Electronic Handbook. And if there's a precise rule that applies.
Do you want me to answer that one, or anyone else want to come in? I'm happy to have it.
Just before you come in, Stephen, that is an interesting, good question, because certainly from a billing perspective, it's not clear in the remuneration regs what rate can be claimed for just lone counsel over 10 years call. Now, back in the day, and Stephen will remember, it used to be £135 per hour for counsel over 10 years call. and 112.50 for council under 10 years call. But now there's no, it doesn't specify for just loan council at all, whether they're senior or junior in the court for working in the for undertaking work in the Courts of Appeal. So from our perspective, based on how Table 2 in Schedule 2 of the Civil Rim Regs currently stands, if we have junior counsel alone acting in the Court of Appeal, regardless of call, we're currently billing it at 112.50. But it would be good to have some
that's
guidance on that.
Perfectly fine. I mean, with the absence of any rates, I mean, obviously the two options are you could claim codified rates as it is civil with an enhancement on top. And if you put a certain level of enhancement on top, or sorry, no, that's excuse me, just the codified rate.
We can't claim an enhancement in the Court of Appeal.
No, sorry, solicitor rates. I was saying, sorry, apologies. But then, yes, you're quite right. Without the ability to claim enhancement on top of that, it would either be £112.50 or £135. I have seen £150 claimed, which used to be the old civil rate, but I will get that clarified. I mean, it's something that if it's not in the regulations and it's not exactly explicit in the handbook, then we need to get it clarified and updated in the handbook. So I will take that one away. I don't want to give you incorrect information on the hoof. So I will take that one away and find out why it's not specifically listed.
Brilliant. Thank you, Stephen. I just want to thank Charlotte, Stephen, and Sumaya for your presentations today and taking the time out of your evening to share your expertise with us. I can see we don't have any further questions in the Q&A box, so I think we'll draw this seminar to a close, and I just want to thank everyone for attending this evening.